Kohberger, CR 0124-31665. We have representing the state, Mr. Thompson, Ms. Jennings, and Mr. Horowitz. And for the defense, we have Ms. Taylor, Ms. Massoff, and Ms. Barlow. Ms. Barlow and Mr. Horowitz, welcome to the fray. I think I saw you back there. And Mr. Nye is here as well. I apologize for missing you there, Mr. Nye. All right, today we have a number of motions to get through. What we don't get through today, we will take up tomorrow. You should have received by email a listing of score sheet of the motions and a rough order that will take those up in, separated into groups. Within the groups, we may not stick exactly to order, and we may take up several within a group if they're related at the same time. And so with that, let's take up defendants' motions in limine regarding inflammatory evidence, use of the term murder, and use of the term psychopath or sociopath.
Thank you, Your Honor. I'm guessing from the court's comments, the court wants me to address all three of those. I'll do that then. Your Honor, the motions are brought to the court based on Mr. Kohberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case with an emotional appeal or an excessive use of emotional phrasing or an excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in, testimony that we may not like that will come in, but what we're talking about is an excessive use of emotional appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying. And that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking about. The court has to do the rules of evidence balancing test, and to do that after the state has elicited inflammatory testimony is difficult to undo and puts Mr. Kohberger in a position where the jury's already been inflamed, and so we're seeking to prevent that. Your Honor, I will move then to our motion regarding the murder term. This motion is also based in Mr. Kohberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses, labeling Mr. Kohberger. That invades the province of the jury. Mr. Kohberger sits here today. He's innocent, and it's up to the state to bring evidence and a jury to decide if that's different. The state, by using that kind of term as applied to Mr. Kohberger, gets in the way of what the jury needs to decide. Back when we were looking at a change of venue in this case, we worked with a social scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Kohberger in their position of authority or ask a witness, especially a witness in uniform, to do so is very detrimental. It's inflammatory to Mr. Kohberger, and it would.
Outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims, perhaps in reference in voir dire, that, in this case, the defendant is accused of murder, I'm having a trouble understanding how this would come up during the evidence phase of things.
Your Honor, that's why I'm asking the court to issue an order to prevent it from coming up.
Sounds like you're asking me to issue an order that says the state shall not commit prosecutorial misconduct, or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of evidence.
I'm sure the state would like one too.
I'm not going to oppose that, Your Honor. We'll get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Your Honor, in an abundance of caution, we bring these motions, and that's based on review of case law and based on years of experience when things happen in trial. I found and I believe that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of.
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
Your Honor, this is my opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that. I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order, and most of all, I think it's protective of Mr. Kohberger's constitutional rights to have that order. That's our request with regard to.
Address sociopath or psychopath?
Yes, I'd like to
The state
address.
was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Kohberger's constitutional rights to a fair trial and due process of law. This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath. Because any kind of testing is unreliable, that would relate to, or that would become problematic within the rules of evidence to do so, and the inflammatory nature of those kinds of labels would.
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This, again, is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
Thompson?
Thank you, Your Honor. And as the court is aware from the responses that we filed, Mr. Nye and I actually kind of divided these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about. He doesn't define the phrase exceptionally inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally, and we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms or their equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't, obviously, the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, and perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. And certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. This, I would imagine, from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say, don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, the state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court
Well,
prefers.
let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit it to the
I think
court
it's
on
the
the
defendant's
filings.
motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's
It is the
motion?
state's
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. This, if you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger, or something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments, that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And defendant replied basically saying the same in their response, that they suggest he use phrases that comport with existing language and statute and jury instructions, and that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of a better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
Nyssa?
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan, and so the state has expressed that they plan to use
How you
that
can use
paper.
it. It's,
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of colloquial term is a prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in-run. The same example that I will give you has to do with
Help me
the
understand
Amazon
your-
records.
I don't think that we're reading the rule the same is the concern I have, and so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position, and another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases, and that also has not been noticed.
But it's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in-run on that with this evidence, and that's why we raised the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is, without notice, they should not be able to argue evidence is a prior bad act or make any attempt at an in-run on that rule.
So I'm not understanding what you mean by an in-run on that rule in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th,
Correct.
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I mean, I think I understand what you're saying. I just think we're
So I think,
completely missing
okay.
each other's understanding of the rules of evidence.
Well, I still stand by my position that the state should not be able to in-run that, and I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or keep
On
it
the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think seat belts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop?
Pardon?
Remind me of the date of the traffic stop?
It is on August 21st, so it's
What year?
of 2022. So it's remote.
Before the murders.
Yeah, yes, before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, well, I can't remember the name, the maker.
Hyundai Elantra.
Hyundai Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state has, the state is.
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera, to me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but.
Okay, well, they've noticed it as 404B evidence, so
traffic stop.
I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
But you don't get
his
to,
phone
and I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it? First you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so can you address that part of it, the prior bad act, and how the court should deal with that? And then also I am concerned with the issue raised about the communication between the officer and Mr. Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. And I think when you review the video, you can put it, the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case, and so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
With regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote-unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so I don't think we can say that the shot clock has run out on that at this point. But certainly, as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, the prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile, and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404, or notwithstanding 404B and 403, I do want the video potentially, I'll look at it, and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer, that was mentioned that, that Mr. Kohberger questioned why the police needed his phone number, that the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant, and it does potentially create some unfair, some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family in general, in terms of a reserve seat. I'm not as concerned about the reserve seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further, that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years, and by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, "Without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged." The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held, the assistant district attorney's blatant abuse of the trial court's subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, who it would be even rational probably for the state to actually call. at best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber, and for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment, has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support Mr.
The reason
Kohberger.
you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them, and picking them up again, and so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into the pot, and at the end of the day, the jury's going to decide whether it's a good soup or not, from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute and bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says a court can't use the exclusionary rule where in good faith a person who was otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you. I'm going to take this matter under advisement. The defense raised some cases. I want to read those, though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that, I can only imagine the family of Mr. Kohberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. But I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course. All right, let's talk about the defendant's motion regarding conditions as an aggravator, and this is the concern about using the defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for a trifurcation with the death penalty, and that was denied, but we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is. We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes Bryan will talk longer than maybe other people want to listen, and that doesn't mean anything.
Well, I assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Kohberger, and that's what we don't want. We want to be able to present, if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has and to prevent the state.
Reading the the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with, how we deal with that with the jury in terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, you know, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that?
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Bryan, against him, to say that he does things that are consistent with autism and that that's an aggravating circumstance. That's,
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
well, I would hope that it wouldn't be presented that way. But, Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I, though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females, okay? And I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to in a mitigation, aggravation, penalty phase. Your position is that's due to his his spectrum disorder, whereas the state's view may, no, that's not, that's his view of women and goes to motive, et cetera, and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state, and
Do you want
I
me to,
wanna
you want
be
me to weigh in and
clear.
say what the factual findings are, that it's this and not that? And I'm not sure I can do that short from a jury instruction that, you know, you cannot use mental health conditions as an aggravating factor.
that's an appropriate jury instruction, and if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present mitigation.
There may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with, and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're gonna argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
Response?
We understand that the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. You know, the state certainly shouldn't make those arguments, and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say, don't make that argument, that the fact of the diagnosis is somehow an aggravating factor. If, and we can deal with the symptomology that the defense contends is part of the diagnosis, that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor. All right. Why don't we take the morning break? We'll take 10 minutes and be back at about 20 till. All right. Let's talk about what I hope we have come to an agreement is not an issue, which is the IGG stuff.
If I may start, and they're battling.
Yeah, I think there are three motions. One is the improper expert testimony of Middleman, who's related to the IGG. The defense, and that's the defense motion regarding IGG evidence generally, and then the state's motion regarding IGG.
Yes, good morning. You're right, Your Honor, that we have essentially, I think, an agreement with the state as to their position and our position being equivalent at this point for different reasons. And I believe that the state is willing to proceed without Dr. Middleman, therefore making that motion moot, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Kohberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Kohberger by name as the possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Kohberger, that set them on a train or a trail to charging him, was the genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think the thing that led to them investigating him was the investigative genealogy. I don't think that's what led to, the only thing that led to charging him.
I apologize. You're true, right? It was what they led them to investigate him and ultimately charge him. But I think that the court could issue an order or at least require the state to make a proffer exactly how they're going to do this. The reason I'm here is because I've done a lot of cases with DNA evidence, and the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer, and the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. And it's not our job to tell them how to do that, but I think the court has to be vigilant.
Well, I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you want to come up with some instruction to the jury that basically says, you know, we're not going to tell you what that tip is, and you don't need to consider it, or something like that.
Is that an invitation?
It's an invitation for you, two sides, to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments?
I mean, we see this sometimes, not in the context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes then we want, we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I have seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity with the jury, and they can get sidetracked. And so we will frequently use an instruction to the effect of, law enforcement's search of the backpack has been found to be lawful, and you should not consider or concern yourself with that, right? And so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important, and you're not to do it. And I think that generally causes them to back off that. And so that's what I'm suggesting that you
Okay.
try to work through.
Okay, will do. Thank you. That's all I have to say.
I didn't mean to cut you off. If you have
No,
anything-
that's all I have to say. That was the only concern that was left for us.
All right, thank you.
And Judge, I think that fairly states where we are. I was curious what the defense meant in their reply where they said that the testimony about the tip should not falsely suggest other evidence, and I still have no idea what that means. But we are happy to engage in discussion about a jury instruction like the court outlined. I will comment that it seems like it took a long time to come full circle because we're right back where the state started a long time ago with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also for the record, there were some pretty serious allegations, ethical allegations made by the defendant in its motion in limine number 11. Those were factually rebutted very clearly in the state's response, and I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
Well, you know, sometimes we litigate issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches and other things, and that's all okay. I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment right now, at least, as it relates to that. To me, this is a practical problem, regardless of the reasons you are in agreement. The important part is that you are in agreement. I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Kohberger that put him on the radar, right? And so I think that's just where you need to come. I don't think for those purposes we're suggesting that the state can't present its evidence about the car, suspected car, about the defendant's whereabouts on the night, et cetera. Those are things that were discovered and put together after the fact, right? I think it is important to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out, and if you can't, we'll revisit how to address it.
Yes, Your Honor, I appreciate that. And the state's intent, we've already spoken with the investigators to develop this, is to have probably Detective Payne, who is one of the leaders and the lead investigators, to simply testify that they've received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thank you, sir.
And so we have a pretrial in next month, and so hopefully you can come to an agreement on how this is going to be handled specifically by that time.
Yes, sir. Thank you.
Anything to respond to, Ms. Barlow?
No, nothing on that.
All right, thank you. All right, that leaves in category A by my score sheet, the alternative perpetrator evidence, which is the state's motion in limine.
It's the state's motion. Do you want to sit here? Oh, I didn't see that one. Why are you sticking that one in there?
Thank you, Your Honor. And this is actually a very convenient transition. We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do
So
that.
for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without making a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on the case law, based on Rules of Evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
That's all.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that, and I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. And so I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial since you're here to take care of that.
Thank you, Your Honor.
All right. And I want to be clear, I don't view Meister as controlling. For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of generic, unknown, unsub, to use the part of the craft involved. But this relates more to allegations of somebody more specific, identifiable. All right. Let's talk about DNA, which is the inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up the third. I think the first two relate to the kind of the same thing to a degree in terms of the science of statistics and probabilities and all that. There are really three issues, as I understand it. One relates to how to convey the statistics that DNA analysts use to more real world comparisons to, for example, planetary population. The second deals with DNA that was found under one of the victim's fingernails and by the DNA analysts as to whether or not Mr. Kohberger could or could not be excluded. And then the third really deals with more sort of this labeling problem that we've already addressed in some fashion in different contexts of what labels should, can, and must we use as it relates to the quote-unquote touch DNA that was found on the knife sheath.
Yeah, yes, thank you. That's a great summary. And I'd like to start with the first point that the court noted, which was motion in limine number 14, which was the relationship of the world population to the statistic generated from the sheath evidence with Q 1.1. And I think we are in agreement that the state is not going to address that kind of question in front of the jury because their own analysts during the grand jury essentially told them that you can't do that given the statistic that we have generated.
I understand the state's response is that they will present the testimony consistent with the way that the witness presented it at grand jury.
Correct, and it was my understanding.
Not in a way in which the question was asked that the witness sort of corrected the attorney about.
Correct, and the objection from the defense was simply, and I think the witness explained this very well, was that the statistical analysis that the state's experts have engaged in does not allow that kind of comparison. It's not the standard statistic that we're used to anymore. And so by asking that question, you're triggering, you're conferring, or not conferring, you're speculating essentially, put in front of the jury. It's a question that presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the testimony as laid out in the grand jury proceedings.
Okay.
Excuse me. The inconclusive data, I don't know if the court has seen that late, I apologize, all of a sudden my voice is
All right,
just
we can get you some
disappearing.
water.
I don't know if the court has seen the latest filing from the state.
I did see it.
Okay, so they filed a new expert disclosure on Monday from an expert who went through and analyzed the data at issue. So as
Response to the defense's having retained an expert who discussed whether or not you could exclude Mr. Kohberger from the DNA found under the fingernails.
yes. And what triggered that was the grand jury testimony, where questions were asked of the analyst regarding the meaning of a conclusive versus an inconclusive data result. And the analyst testified as to 13.1, the fingernail swabs, that their data was inconclusive. And to the defense, and that means that you cannot draw any conclusions. So the defense retained cybergenetics, which uses a different statistical tool than the lab here, and generated a statistic which is strongly exclusionary of Mr. Kohberger from that particular sample. And while that doesn't preclude the evidence from the state lab, it adds additional information to the picture, the overall picture, and it's
It's just a question for the experts to testify about and the jury to make its conclusion.
well, I think that allowing the type of questions and apparently now the new conclusion that was in the state's response to our motion would be inappropriate and prejudicial and should be excluded under and you have to.
Do you want me to believe your expert and not their expert?
No, I'm not asking you to believe any one in particular. However, what I am saying is that the amount of time and energy it will take to explain what inconclusive means is essentially far greater than should be the job of the defense to do. Inconclusive means inconclusive. No, I'm not saying that. I think it can be presented, and it can be presented in a fair manner that is consistent with due process and the right of Mr. Kohberger to confront it. The new disclosure from the state is an expert who went through in great detail. We have a 27-page report from him where he not only reanalyzed the data visually, but he also used another statistical tool. And he stated in his conclusionary paragraphs, and it's a very long report, that first he looked at the data using the lab's protocols and doing some validation himself, essentially looking at their validation studies. And he found that just visual examination of the data excluded Mr. Kohberger. He went a step further and he said, I'm going to use this new third tool called LR Mix Studio to generate the same statistic or similar statistic that the lab did, the state lab did, as well as True Allele Cybergenetics did in their analysis. And he came up with a strongly exclusionary statistic. So we have now before the court, as he describes it in his disclosure, a statistic from the state lab, which means that it's 25 times less likely if the DNA originated. I always have a hard time with these numbers because you have to be extremely careful how you say this because it can flip the meaning. So let me just double check. His statistic, I'm sorry, I'll start with his. It's 5,000 to 100,000 times less probable that a coincidental match would be made to an unrelated person. In other words, what he's saying is that Mr. Kohberger is not included, and that's a strongly exclusionary statistic. And I'm not saying this very well, Your Honor, because these likelihood ratios are hard to explain. So that's a 5,000 to 100,000 times less probable that Mr. Kohberger is present. In other words, it's much more likely someone else is there if there's someone else there. Then the cybergenetics came up with a number that is in the range of 2.8 billion times less probable that he is there than some other unrelated individual. And this expert then relates that even the state lab's number is 25 times less likely that Mr. Kohberger is there than some other unrelated person. So all of the numbers point to exclusion. The numbers, the question is really the weight of it. And the way that the state intends to present it, and they presented it in their reply to our motion, was they should be allowed to say that this means that Mr. Kohberger cannot be excluded. And that is just a misrepresentation of their own data. None of the data that's presented to this court at this moment in this motion supports that statement or that conclusion. And it's unclear to me who is going to say that, because it's not in any of the disclosures that have been produced so far. The first time we've seen it is in this reply brief. So I think that rather than having a battle of the experts, right, where you're going to have all three of these people testifying before the jury, and to allow that just one question is going to subsume an enormous amount of time in explaining why it's not in it, why it's inaccurate. And while it might be technically true, it's not an accurate statement for the jury to consider, and it's just going to confuse them. And it's highly prejudicial to Mr. Kohberger. So we would ask the court to, if it's going to allow this in, and we haven't asked to exclude the evidence, we simply asked the preclusion of this kind of questioning, that the state be precluded from inferring or asking a question to elicit some kind of inclusionary statement. I hate these numbers.
Your Honor. So let me just explain a little bit about the state's position. The state has no intention of suggesting to the jury that, oh, maybe this is Mr. Kohberger's DNA, we just don't know. That is not what the state is trying to accomplish. What happened is the Idaho State Police Lab tested this DNA, and they came up with their likelihood ratio, and that number fell within a buffer zone. And under their policy, that buffer zone, generally speaking, with a likelihood ratio, anything less than 1 suggests exclusion, greater than 1 suggests inclusion. But they had done their own internal validation studies and had found that they were getting some false positives and negatives when you're close to that 1. And the range that they came up with was 0.01 up to 100. And so their policy is, if it falls within that range, 0.01 to 100, we report it as inconclusive. Not just meaning you can't, uninformative. You cannot draw one way or the other, whether it's exclusion or inclusion. And so that's what we had from the Idaho State Police when we went to the grand jury. We thought that it was important. What we were trying to portray to the grand jury was that there was the only DNA that connected Mr. Kohberger to the crime scene was on the knife sheath. But the analyst wasn't willing to just make that general statement because there was this issue, this
I
inconclusive.
understand it's not the state's position that DNA is or likely could be Mr. Kohberger's under the fingernails, that it's unknown people from however the victim lived her life in the hours, days before this event, and whoever was the perpetrator may have been clothed in a way that fingernails didn't contact skin. I assume that's the state's position.
That is exactly correct, Your Honor. The state's theory here is that one would not expect the perpetrator's DNA to be under her fingernails given the eyewitness account of what the perpetrator was wearing, the complete lack of any defensive wounds on this particular victim, the toxicology report. All of that suggests you wouldn't anticipate this to be the perpetrator. And so we have no,
So does that mean the state's not going to present this evidence in a way that would suggest or argue that it could be Mr. Kohberger's DNA?
absolutely not, Your Honor, no. And that was part of that rather lengthy, I admit, report that was submitted on Monday was to demonstrate, yeah, when you know, the other issue to keep in mind is the Idaho State Lab uses a different program than the True Allele program that was used by the defense experts. So the Idaho State Lab pointed us to someone else they were aware of that used the True Allele program and said, why don't you speak with him? We spoke with him, and he came back with the same result, exclusion. Nevertheless, given their policy, the ISP analyst is not willing to say he's excluded because their policy prohibits her. But the plan for the state, to the extent it addresses this, is for all of that information specific to her about the policy, and it fell within the policy, and that's why I'm saying that's what the state would present. And of course, she's open to cross-examination. Of course, the defense can put on theirs that can say, no, we can say he's excluded. The state has no plan or intention to in any way ask questions, imply, or certainly argue that this DNA belonged to the defendant. That, again, we will actually be arguing much different than that, that you would not anticipate the perpetrator's DNA to be under the fingernails. And so that's where that is coming from with the inconclusive data. On the issue of the statistical analysis, that we agree. I mean, we're not going to ask that question. The only kind of remaining issue we have is I think their motion specifically asked for an order excluding that question or other questions like it. I'm not a big fan of that language because it's just kind of vague and we're not entirely sure what that means, but we'll stay completely away from the population of the world or a country or a city or anything about population. That's all. Thank you.
I would just like to say, Your Honor, that I guess we're in agreement, and as in an abundance of caution, I might ask the court to issue an order just that if things change, that the state has to come to the court before even trying to present such evidence.
Thank you. It sounds like, and I'm not trying to tell either side how to present their evidence, that the state's not intending to present the fingernail evidence as somehow being inculpatory. I could see, based upon cross-examination, et cetera, the defense questioning the lab person in an attempt to maybe attack the credibility of the lab, which then may require the state to put on its rebuttal expert that it's identified as to that issue. But I think we're at this point safe, based on what you've said, that the state does not have a good faith basis to suggest that the DNA, to make an argument that the DNA could be Mr. Kohberger's, that they not do that without first talking to me outside the presence of the jury based upon what the state of the facts on the ground may be at the time. As to how you question with respect to statistical analysis, I guess as guidance, it seems to me the answer that was given to a question that the analyst kind of rejected is probably the way the state ought to approach it, but I'm not going to tell them exactly how they have to ask the question. What I will say is I will make sure I'm aware of the way that it was asked in a way that was concerning, and certainly if a question is asked in a way that is concerning, the defense can object, and I can respond accordingly. All right? All right. next motion to eliminate is Defense 12 regarding the make and model of the suspect vehicle. Oh, I'm sorry, did I miss one? Oh, you're right. Within the group I identified before was the touch DNA. I apologize.
Still in DNA.
Yeah,
Your Honor, this is basically a two-part motion. One is to exclude the use of the term touch or terms touch and contact, and the other is to specifically exclude an opinion of Rylene Nolan regarding the sheath DNA and her conclusions as to the how, what I call the how and the sort of when the DNA that was determined to be on that sheath, item 1.1. And I'll start with the touch and contact language. Admittedly, that is language that has been used for a number of years in the.
your own expert used it.
Yes, she did. And we would be fine with the court precluding her from using that term. I think what is happened in the world of DNA, having been doing these cases for unfortunately 30 years, is that there's been an evolution. And we laid that out pretty well, I think, in our papers, an evolution of DNA testing, where people started realizing the sensitivity of this methodology allows you to pick up DNA from objects that have no visible stains, like no blood, no saliva, no semen. And that led to the use of the term touch or contact, because the implication and the theory behind it was that people who touch things leave things behind, leave DNA behind. We've now moved into a world where we know that not only can people touch something and leave their DNA behind, but for instance, Mr. Nye was just standing up here. He was touching the podium. I've now placed my hands on the podium. His DNA is probably on my hands. And when I sit down and pick up my phone later, I could transfer his DNA to my phone.
Sure. But
Nobody's gonna.
it'd probably also include your DNA too, right?
Of course, but not always. And the problem with the use of those terms is that it essentially allows a conclusion to be presented through a description. And there are many, many, many ways to describe touch or contact DNA. And Ms. Nolan illustrated that in the second disclosure that was produced. And I have copies if the court does not have them. If you would like to review those, I can have them marked. And she goes through her entire discussion of transfer, which is the question here, transfer. How does DNA transfer? And how did it transfer in this case? And she does not use the word touch in describing that process. It's not essential to the description of the process. It's not essential to the explanation of how DNA moves in the environment, because many of the things she's talking about with transfer happen with any biological fluid, not just skin cells. It happens with blood, saliva, etc. So it's essentially allowing the state to prove something, a very important fact in this case, simply by asserting that the term touch DNA is usable or acceptable in the forensic community. We presented at least 3 sources that say, and these are reputable people who are publishing in reputable journals, saying that this type of language is misleading, and it can lead to a misunderstanding of the evidence itself, because touch DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from a person has gotten to an object, whether that's through direct or indirect contact.
I assume your expert's going to tell the jury all that.
I'm sorry?
I assume your expert's going to tell the jury all that.
Yes, and Ms. Nolan will be telling the jury that as well if she testifies.
So what are we worried about?
What we're worried about is that it's confusing to the lay person to hear an expert use a term that is essentially a description of activity. I'm not very good at grammar, but I believe that's an adverb. And it is not one that is useful for a jury, and it will be misleading because ultimately the experts will be discussing a much broader source of what we might call contact or touch DNA, which is anything that comes from a human being, including saliva. or blood. Just because you don't see it, just because you can't see a blood stain doesn't mean it's not that stain or that area that is sampled doesn't have some other biological fluid. So it's very misleading. And it's just not necessary. And there's a paper that was presented as a human factors report that was published last year where the consensus, although there were 2 dissenters, is that analysts should not be using this kind of language and not proffering, and this goes to the next question, not proffering opinions about this, but that the language itself is extremely misleading. There are other ways to talk about it. Ms. Nolan rejects the term trace. That was just one expert's opinion in one article that was cited to the court. But it's very clear she doesn't need to use that term in her description of how DNA moves in the environment. So we would ask the court to prohibit her or any other witness, frankly, from using those terms in describing any DNA sample that's been collected in this case. As far as Ms. Nolan's opinion, again, it goes hand in hand with this idea that touch DNA or the contact DNA is not what it used to be thought of. And there's a number of publications, scientific journals, where the scientists have reviewed vast quantities of scientific literature. I think I counted up over 300 articles in the 2, were reviewed by the 2 articles that were cited in the moving papers that say that there is really no way for a particular analyst in a particular lab to determine how and when DNA was placed on an object when you don't have any facts behind it. In other words, unless you see something or you know something, you have facts of the method of transfer, it's not possible. So first of all, Ms. Nolan is not qualified to offer such an opinion. It's very clear from the growing consensus in the community that transfer in and of itself, how things get places, is a separate expertise which requires separate training. And a DNA analyst working in a laboratory does not have that kind of training. And in fact, it's not really provided in the United States. There is a paradigm in Europe that is being used, but it's not been accepted or used here in the United States at this point, which is the concern from some of the experts who were on the human factors report. But Ms. Nolan is not at all qualified. If you review her CV, which was part of, I think, the first disclosure in December of last year, going through the list of courses that she's attended, none of them are specific to transfer. And in her affidavit that was supplied to the court, she discusses attending some presentations at a recent meeting where there was discussion of transfer, where some unnamed individuals disagree with this idea that it's not something that should be testified to. But I think there's that her presentation, and this is what the court has to consider, the facts presented by the state in support of their opinion, is not supported by anything other than this vague statement, well, some people don't agree with this position. We don't know who those people are. The state and Ms. Nolan have presented no particular scientific articles that support her opinion, and she has presented no specific training to take her from an expert around DNA testing, which no one is suggesting she is not, to an expert on the how and the when of transfer in this particular case. Then, when you look at her opinion, I think the court has to exclude it because it's highly speculative and it's incredibly confusing. She first states that the consensus in the community is that you cannot determine when and how DNA moves onto a particular object. She says that without any qualifications, that the science doesn't support that. She then proceeds to say the DNA on the sheath could have gotten there through indirect transfer, meaning it was not placed there by direct contact of a hand, for instance, with the object. And then she goes on to say, but because of two facts, the quantity and the fact there's a single source, I believe it got there through direct contact. She offers this court absolutely no information to support that. She doesn't.
Other than those two things.
I'm sorry?
Other than those two things.
Well, yes, those are two facts, but those facts and the meaning of the facts are relevant. We cited a number of cases that talk about expert witnesses and speculative opinions, and our position is that this opinion is so speculative and so confusing that it shouldn't be presented to the jury, in great part because Ms. Nolan does not present this court with anything to support her conclusion. She's basically saying the science says I can't do this, but I think I can. If we were in a different place where we had some articles to support her conclusion, if there were articles to support the fact that the amount of DNA or the fact that it's a single source sample is probative of that the scientific principles and methods of DNA testing support that, then we'd be in a different place. But that's not where we are. We're here with a naked opinion with no foundational facts to support it, other than Ms. Nolan's training and experience. And while training and experience is a relevant consideration for this court, we don't even know what training and what experience she's relying on. We don't have any indication that the lab has done any studies internally about this question. We don't know what literature she's been reading. And frankly, even though she attended this meeting that was held in February, where the proceedings are online and available, she didn't bother to let the court know who spoke and what they said. So I think the reason is because she doesn't have any support for this. And it's going to be incredibly time-consuming, not only to cross-examine her, but to present evidence to rebut her opinion. And given the speculative nature and the sort of both sides of it nature, I think the court has to exclude it.
Thank you, Your Honor. I'll start where she left off. I don't think she's accurately characterizing what the opinion that's been disclosed. Ms. Nolan did not say, I agree that the science says you should not opine on this or that you cannot opine on this. All she says is that the science does say you can't conclusively establish it. But there are factors, she lays out a lot of those factors that you can look at to decide, to indicate how it ended up there. And she's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, it was primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations, and she's giving her opinion, which is going to assist the jury in reaching their conclusion, because the jury's not familiar with any of these factors that she's laying out for them. So, and then as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for 2 decades. She's a forensic scientist. She specializes in biology and DNA. For the last 10 years, she's been the lab manager and overseeing all of the biology and DNA. That includes instructing, as indicated in her CV, law enforcement and others on the collection of DNA. What we're discussing is a critical component of all of that, which is how does DNA get from one place to another? She has plenty of experience to talk about that while admitting that she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say to a scientific certainty that this is in fact the case. Now, on the issue of the touch DNA and just the label itself, I don't know that I've ever litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. And she didn't just use it, she used it specifically in reference to the DNA on the knife sheath, the exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case use that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury. Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that. I don't think it's outside the bounds or intellectual capacity of a juror to understand that sometimes in particular professional fields, there are phrases used that may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it. Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert, but their own expert, they're admitting that there's something there to be cross-examined. And so if this court orders there can be no statement or no mention of touch DNA, then I think that cuts off a very legitimate line of cross-examination from the state.
So, I'm not particularly fond in general of proscribing phrases and words that can be used by parties and witnesses in cases. I think it just creates the potential that you're going to have problems because people slip, and particularly when you're using phrases and words that are commonly used within the field, right? We see that all the time with the use of the term victim, right, in cases, and the Supreme Court has recently weighed in on that issue. And there's actually an ICHE instruction that deals with the use of the term victim because it's just, it's hard to police phraseology. On the other hand, if what we're talking about is an agreement that, this term may be implying something that we all agreed isn't necessarily true in all cases, I mean, we could call it blueberry DNA for all that matters, right? And your experts are going to explain what it means otherwise. What's the concern here if we say, let's try not to call it this? Other than accidental violation and now somebody's asking for a mistrial, right? I mean, that's one of my concerns.
So in reality, that's really the state's only concern is we don't want to get in a situation where there's a word that's off limit, and because she uses it, the defense expert uses it, it slips out at one point that suddenly we have a motion for a mistrial because there was a violation of this court's order. As defense counsel mentioned, Ms. Nolan didn't rely on this word heavily much at all in her opinion, and I don't anticipate her testimony to be anything different. But if at one point in the back and forth, either with us or with the defense attorney, she slips and says the touch DNA on the knife sheath, I don't think that that's a problem, and I don't think that it's something that this court should restrict. I think both of these experts felt comfortable and wanted to use that phrase. That's why they used it. I don't think it's superfluous. I don't think they just said touch to say touch. I think to them it means something, and it's accurate to use it in this case with respect to the sheath. But certainly the state has no problem encouraging Ms. Nolan to avoid that word to the extent it's possible.
Thank you.
Thanks, Your Honor.
Just a quick response. Language is important, and language in science evolves and changes. Ms. Nolan and Dr. Ballard, our expert, are scientists. They present themselves as experts, and I think that scientists should be held to a slightly different standard than the average witness. And the use of language, as this court pointed out to me early on when I first stood up here, is really, really important. And I am confident that Ms. Nolan can restrain herself from using that language, and I'm confident that all of the parties can ask questions that do not elicit that kind of information or use those words, and I would encourage the court to restrict the use of those words for this proceeding. As far as Ms. Nolan's opinion, no one is asking for certainty. Nobody expects scientific certainty. That is not our position. The question is it supported by the science that Ms. Nolan is essentially testifying about? And the answer to that is no. Her personal opinion is not science. It is a personal opinion. And if the
We're relying on a scientific report to which there were dissenters.
Yes, but the dissent was not about the content of the recommendation. The dissent was, we don't have any options, and maybe we shouldn't be requiring trainings that are not particularly available in the United States. That is the nature of the dissent. And
But in support of the idea that this testimony shouldn't be precluded by these people.
I'm sorry, I couldn't,
But in support of the dissent, in support of
yes.
opposition to a scientific consensus that this testimony should not be presented.
That's correct, but I don't think that the court has to rely on a 100% consensus of the community. I think that the evolving understanding of the science and the scientists in this area and of the people who are actually publishing work is highly relevant to whether or not that kind of opinion is actually acceptable anymore. And I suppose that the question of admissibility might revolve around a more like a Daubert standard. But given that we have not had the opportunity to see these opinions until so recently, that was not something we were able to do.
The Supreme Court has specifically rejected the Dover standard.
Well, I'm new to Idaho law, Your Honor, that's why I suggest Daubert. But that kind of analysis, I think, is the same type of analysis that this court has to do, as sort of essentially a gatekeeper to make sure the jury is hearing reliable evidence. And I think that if you read closely, in particular, Ms. Nolan's second disclosure, which I believe came out in February, or was given to the court in February, she lays out a whole series of things that affect transfer. She makes one statement about the quantity of DNA being higher with direct transfer, but that's not elucidated in any way, and doesn't talk in anywhere in that disclosure or any other disclosure why a single source profile would support her contention. And I think because of the complex nature of this, that we can't speculate as to why. It may make logical sense, but I'm not sure it makes scientific sense to speculate, which I think is what we are prone to do. And as I think the Idaho courts have said, the court's not supposed to substitute its judgment for the expert's opinion, but to consider it in the context in which it's presented. And here, there is nothing to support her opinion, absent her assertion of training and experience. I'll stop with that.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA. As to the use of the term touch DNA, I'm not going to preclude it. As I indicated, I think it's a discretionary matter. Science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as the term victim, there's an instruction for. I'm not opposed to giving an instruction to the jury should that term come out, that the court is not intending to, by use of that term or by any of the attorneys' use of that term, making a conclusion. On the other hand, I do encourage the parties to not use the term as much as they can. I think we underestimate the intelligence and reasonableness of jurors, having presided over, I don't know, well over 100 jury trials. I think that we worry about things that they are more than competent to understand and not jump to a conclusion simply by the use of a word, particularly where there's scientific testimony around explaining what that word means in context. And so I'm not particularly worried about it. I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a council at least, try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage council to try to avoid it as much as possible. All right, now I think we're on the make and model of the suspect vehicle.
Your Honor, this is a motion where the words do matter. We're following up on that one, this seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number 1. That invades the province of the jury to make that determination. The state has Special Agent Emmett, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Emmett insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number 1. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number 1 has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle 1 to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Imel. It is his opinion that the suspect vehicle, captured on various surveillance video, shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video, while some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion's based on logical inferences of review of the surveillance and footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information with other testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014-2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Your Honor, our request is not at this stage to limit Agent Immel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle in all of these clips. Agent Immel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips, that
No.
his expertise?
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
Not actually factually true, as I understand it. It was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Franks motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are, in the email, it was originally, let's look at this date range, and then he said, well, you know, I'm more comfortable with an expanded, or we need to expand the range through 2015, and that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist, you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect Vehicle 1, and so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
Right. So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it?
Yes, it was my motion.
Sidetracked there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect Vehicle 1 is making a specific conclusion. It's, again, using a term that is used within the investigation, but specifically making an argument that the various vehicles, or the various images of vehicles on the various surveillance cameras is the same vehicle, making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be, right? As to the agent's ability to make that conclusion, I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes, and then we will come back shortly before 1, but no later than 1.
All rise.
the video's running? All right. Bushy eyebrows, I think, is next. This is a defense motion.
DM is considered an eyewitness, and eyewitness testimony is some of, if not, the most impactful testimony in a trial. The testimony must be subject to close scrutiny before its admission is allowed. We seek that the use of the descriptor, bushy eyebrows, be excluded from use at trial because the witness with this descriptor is completely uncertain of what she remembers, and her description is derived from seeing the intruder for only a second. Whether this court applies Manson-Biggers, which I would say is not completely right on point because there wasn't a photo lineup and there wasn't a show up, or the court considers the science behind memory, the criteria you must look at is what factors influence the accuracy of the memory and make the testimony reliable, because reliability is the linchpin in determining the admissibility of identification testimony. Between Manson-Biggers and the science of memory, there are several factors that are consistently considered, and I'm going to go through a few of those. Factor one, what was the opportunity to see? This is also known as first phase of development of memory or the acquisition phase, and distance, lighting, and duration of exposure are important. DM is uncertain about the lighting. The stairs to her left were not lit. The kitchen may or may not have been lit, and the twinkle lights in the living room may have been lit. She described seeing the person for, quote, only a second, end quote. The person may have been 3 feet from her, or he may have been walking to exit out the back sliding glass door. The back door is further than 3 feet from her door and is not visible from where she was standing. We submitted 2 pictures as our exhibits to show you the vantage point of where she was standing in her bedroom. Her opportunity to see supports unreliability. Factor 2, the witness's degree of attention. This is where amount of alcohol has a significant impact on the analysis. She described herself as, quote, probably very drunk, and given the amount of alcohol she told law enforcement about consuming the entire day, that makes sense. She started with champagne mimosas in the morning, then White Claws 9 to 10 throughout the day. Then that night before she got home, she was involved in a drinking game and drank Borg, which is hard alcohol and flavoring. Her degree of attention, given this, supports unreliability. Factor 3, the accuracy of the description. Her description is that she saw a person wearing all black, not insanely tall. She doesn't know if she saw lips and nose. She is certain he is white. She never mentions eyebrows herself initially. The person who asked about eyebrows was law enforcement. In her second interview, Detective Mowry asked her if she saw the eyes, saw eyebrows. She never said anything about bushy eyebrows. Then in her third interview with Detective Gooch, she said she didn't know what the eyes looked like or the color of the eyebrows. That's for the first time that she mentioned bushy eyebrows. This lack of accuracy supports unreliability. Factor 4, what is the level of certainty of the witness? In each of the 5 interviews, she says over and over again, she doesn't know if anything she says is accurate because she felt like she was in a dream state, frozen shock, fuzzy and cloudy, like wearing blurry glasses, influenced by alcohol, and sleepy. She has an absolute lack of certainty. This supports unreliability. Factor 5, the science of memory looks to confabulation. When the acquisition of memory, the first factor that I talked about is impacted by emotion and stress. In this case, that is an important consideration. Confabulation is defined as the creation or substitution of false memories through later suggestions that fill in the gaps of missing memory. DM expresses in each interview how she was afraid and did not know what she was hearing, and also contradicts this when she thought everything was, quote, okay, and XK was simply just passed out on the floor. Later suggestion, under this definition of confabulation, is Detective Mowry asking her about eyebrows and each law enforcement officer, then reinforcing that in each interview. She never used the word balaclava, yet Detective Gooch asked her if she had ever heard of one, explained what one was and that it's used to hide identity, showed her a picture of one, and then had her draw one. This is law enforcement filling in the gaps. This also impacts the last factor, which is factor 6, post-event misinformation effect impacting retained information, exposure to subsequent information. Law enforcement, upon initial appearance at the scene, did not ever break up all of the people that were there. They then go to the police station, and after that, on the night of November 13th, those that were at the house when law enforcement arrived stayed together in a hotel room. So the DM was basically together with other witnesses from the time that when they first called friends to come to the house, before they called law enforcement, all the way through the night. She was interviewed twice by law enforcement. That created this exposure to bushy eyebrows. And then that term was used in the probable cause affidavit, and the media seized upon it from the very beginning, causing post-event exposure, which affects how DM's memory is retained. This factor supports unreliability. When you look at all of these factors, or the totality of the circumstances, the way the state argues it, the linchpin, the reliability is not there. The state wants to bolster a person who admittedly has no clear memory with a photo of Mr. Kohberger to say, this is the person she identified. DM told police that she looked at Mr. Kohberger's arrest picture and did not recognize him. The state cannot run around her unreliability by entering into evidence a photo to show it's a person that she says she cannot identify, because the state's interpretation is that Mr. Kohberger's photo shows bushy eyebrows. That is misleading to the jury. It will confuse the jury. It will be putting words into the mouth of DM that do not exist. While they might not seek to do that on the stand with her by admitting a photo through her testimony off of his phone, if they make the argument in an opening statement that that description of bushy eyebrows is supported by a photo taken on his phone the next day, that kind of prejudice is beyond repair. The state also claims that because DM draws pictures of eyes and eyebrows, she is more reliable in her identification of them. But that is not the way law enforcement appeared to have viewed the artwork as they photographed it and reported on it. Given the science of memory and its acquisition, retention, and retrieval, this could be what is filling in her memory gaps as opposed to actual memory. When you apply the critical factors that a court must take into consideration for eyewitness testimony regarding identification, the words bushy eyebrows should be excluded. The heart of the issue is whether or not the witness is reliable enough on the issue to let the words be spoken to the jury when it comes to the description. DM said that she could not do a composite sketch because she doesn't think she saw a face. The court should enter an order excluding the words. Thank you.
The defendant relies on the Manson-Biggers test. We just went through the 5-factor balancing test for their argument. However, that test is completely inapplicable in this case. Manson-Biggers has to do when there's a law enforcement-led identification process. The concern is that through suggestive techniques by law enforcement, it could lead to or create a misidentification. Well, that didn't happen in this case because it couldn't happen in this case. The male DM saw that night was covered head to toe. The only thing that was uncovered was a portion of his face. That does not lend itself to positively identifying any particular person. Therefore, an identification procedure was not used, and that Manson-Biggers test is inapplicable. Instead, on 4 separate occasions, before Bryan Kohberger was even identified or arrested, DM gave consistent descriptions of the male she saw in the residence that night at around 4 a.m. Every time she described this person as being white, male, wearing all black, a few inches taller than her, she's 5'10", wearing a mask, skinny, athletic, toned build, and not a voice that she recognized. During 3 of those interviews, she then describes the male's eyebrows, and she describes them as being bushy. Obviously, there was some focus on the eyes or the eyebrows by investigators because this is the only portion that she could see. She never wavers in her description of the person that she saw. She's very clear about what she does remember and what she doesn't remember. Defense put the state of Mr. Kohberger's eyebrows into question. In an attempt to discredit DM's testimony or description, they wrote, "Mr. Kohberger does not have bushy eyebrows, but the artwork on DM's walls and the way she draws eyes and eyebrows could be described as bushy, full, or prominent." So in response, the state attached a picture of Mr. Kohberger, and obviously that's a jury question, but it was taken only hours after the homicide, so the closest in time to when DM would have seen this male. And we did this in order to, when we did apply the Manson-Biggers test, to show that it turned out to be accurate. Corroboration does not equal prejudice. The state doesn't intend to introduce, they're correct, we would not introduce that photograph through DM. We would attempt to introduce that photograph and plan on laying the proper foundation and relevancy at trial. There's no grounds to exclude this testimony. DM's the only living individual who saw the person responsible for these 4 homicides. Her description of the male, including any characteristics such as bushy eyebrows, is relevant to the identity of the killer. It is prejudicial, but it's not unfair. A jury should hear this evidence, and the state asks that the court rule accordingly. Thank you.
I'll be brief, but I want to circle back to where I started. To say that there's no grounds to exclude this testimony is completely inaccurate because, in fact, there is a large body of case law and a large body of science about how important this testimony is, and that's why this court must analyze the reliability going through all of the factors that I expressed. And there is not certainty with DM in what she saw, and the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
Thank you. I'll take that issue under advisement. Text message, pardon me, 911 call.
Judge, the state seeks a pretrial ruling that the audio recording of the 911 call and a transcript of that call are an exception to the rule against hearsay. The state submits that the entire 911 call should be admitted pursuant to IRE 8032 as an excited utterance. At 11:49 a.m., BF calls her friend and to come over and check the residence. The friend and a boyfriend show up to the residence. At 11:56 a.m., BF places a call to 911. Just 7 minutes later, this 911 call was immediately after learning that HJ had something was definitely wrong within the residence, and his instruction that the girl should call 911. The statements were before the declarants knew their friends had been murdered the night before. The requirements of IRE 8032 are met, as this was obviously a startling event, and two, the statements were made under the stress and excitement that it caused, and that's clear by listening to that audio. The defendant has proposed that their version of the 911 transcript be used, and the state has no objection to that. And I do have a copy of that transcript and the defendant's transcript, if the court would like it. Thank you.
Well, I may ask you some more questions because it seemed to me from the briefs that the defense focused in on three particular parts of the 911 call as not falling within the exceptions. So you didn't address those specifically, but let me see where the defense is at.
Your Honor, the best place for me to start is to probably provide you with some copies of the exhibits that we're going to want to talk about. The first set I'm going to hand you was actually filed with the text messages. It's an affidavit of Josiah Roloff, and also, let me give you the extra copy. It has DM's messages broken out in bubble form. That's not all. I gave a whole separate copy for Giovanna. I think that's what I'm supposed to do.
This, to be clear, when we're talking about 911, but you're giving me the text stuff?
We are, in our response to the state's motion about the 911 call, we referenced the whole copy of text messages. We just filed them with text messages, but they're appropriate here for the court to consider. I have the additional exhibits that were attached to our response, and they are 1 and 1A. 2 copies. With those in possession of the court, I'll talk about the state's request. The 911 call is made 8 hours after whatever happened in that house happened, after the killings happened, according to the state's theory of the case anyway. The state wants to play for the jury the 911 call and give them a transcript of the 911 call as an excited utterance or a present sense impression. The context of all of what happened that night is captured in DM's text messaging. There's a separate text messaging exhibit for BF. But it's not that all of a sudden at 4 a.m. something starts to happen, and then the 8 hours pass, and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. and he really doesn't say a whole lot. The other statements that the state wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript, and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went in, went to the top of the stairs, and went back out, and she saw nothing. She never went back inside that house. Any statement attributed to her cannot be an excited utterance. She's repeating what other people have told her. Similarly, if you look at the grand jury transcript, this is 1A, this relates to DM, and I'm at page 187, lines 12 through 16. DM is not responding to any of the statements she makes on the 911 call to a startling event. She says that for a brief second, she saw XK, but thought she was passed out from the night before. She also wants to talk about what she saw at 4 in the morning, and the dispatcher stops her. Looking at page 190 of that same 1A transcript, DM talks a little bit about that morning when she woke up after whatever happened in the middle of the night happened inside that house, that she reviewed the text messages between her and BF from the night before. She was busy from about 9 o'clock in the morning on her phone. She was on Instagram, she was on Snapchat, she was on Indeed, she was editing pictures sometime in the night as well. This is not somebody who was asleep and then woke up and was startled. She is actively reviewing things that happened on her phone and communicating with other people. Any statement she made on the 911 call is not the result of a present sense impression. It's not the result of an excited utterance. It is somebody who's been awake and thinking about whatever she and BF talked about the night before and communicating with a lot of other people before that 911 call is made. The court should not admit the 911 call as an excited utterance, and the court should not admit the transcript for the same reason, but if the court chooses to admit one, having both is cumulative. So I would ask the court to exclude the 911 call.
Judge, I think there's a misapplication of the rule as well as the event that is causing the startling event, or the reason that they're startled. State agrees that this is somewhat of a culmination. There was definitely a startling event around 4 in the morning when DM opened her door and sees an unknown person in black in the house. She's not sure what to make of this, but that's obviously a startling event, enough so that she runs downstairs to her friend's bedroom. Yes, a period of time elapses. She wakes up the next morning. The next startling event is the fact that when she wakes up the next morning, her friends, she can't hear them. And she's texting them, and that's what her phone records show. She's texting them, giving them time to respond, and they're not responding. So at this point, she decides to call over friends to come and check on the residents, remembering what happened the night before. Now adding to that, that she's not hearing the roommates above like she normally would, and they're not responding in the morning like they normally would. Then she calls her friend to come over. Then the friend comes over, discovers Xana and then instructs them something is wrong, and to the point that they need to call 911. That's truly the startling event here, is the confirmation that all of these things are coming together and that there's an emergency in the house that law enforcement needs to respond to, which is the context of how all of these statements are made.
What do I do, or what's your response to it seems like some of this I need to take bit by bit. And so, for example, EA stating that one of our roommates, or one of the roommates passed out and was drunk last night, and she's not waking up. She didn't witness anything.
Well, I think that falls under her present sense impression of what is happening at that time.
Her hearsay statement of what somebody else told her.
That's
She's
true.
not experiencing anything in that sense, other than being there. And I think the case of, look at my note here, of Bemis is instructive.
Well, I would also argue that for this particular statement, we wouldn't be relying on it for that truth. So therefore, it's just not hearsay. Well, solely just for the context of the entire 911 call. But we wouldn't be asserting that what she was saying is true, that the roommate is passed out and she's not waking up. That's not the purpose, or that my friend's telling me that she saw someone in the house last night.
Tell me it's not offered for the truth. You better have a good answer about what the reason is other than the truth, and I'm not hearing one.
Only that it's part of the substance of the entire 911 call, and that part could be redacted, that doesn't mean that the entire call should be redacted.
So I'm addressing them individually. I mean, there may be parts that qualify and there may be parts that don't.
I still argue that the entire call in its entirety.
Well, so here's kind of the way that shakes out. If you offer the tape, you, as an initial matter, can't put in stuff that is hearsay. It's unaccepted hearsay. If they want to put in the context, if it falls under the completion doctrine, they can. If it's the other way around, in the defense first plays the tape, and parts are hearsay are left out, and you want to complete it, you can. But you don't get to complete with hearsay your own offered conversation, or I think it applies outside the federal context to recordings and testimony.
Yes, that makes sense to me.
So when you say for the whole context, that sounds like the completion doctrine, which I'm not sure you get to rely upon. Well, I know you don't get to rely upon. And so when you say it's not offered for the truth, I'm not hearing something other than the completion doctrine that you're telling me about.
I think that's fair. I mean, we only have certain exceptions to the rule. I still believe that the entire call in its entirety, and under the circumstances that the call was made, the entire call could be considered an excited utterances by all declarants.
Also, there's a statement by EA, and they saw some man in their house last night. Yeah. That seems to me to even be more removed. Again, it's a statement of a hearsay of somebody else, so you got hearsay within hearsay, and not by somebody who observed that, and relating to the event that happened previously.
That's true.
So what non-truth purposes is that statement?
Again, I would just have to say that the whole
Because
call is
that seems
excited.
to me to be even more concerning,
Right.
right? The first one, I mean, my roommates aren't waking up, and we're gonna have that confirmed through other evidence. The statement hearsay that the roommate saw somebody is perhaps more of a piece of contested evidence.
Agreed. I still,
Concern about being an offer for the truth is even greater there.
right, and the appropriate remedy, when there's not any grounds for relevancy for this, would be to solely redact those portions of the 911 call, not to exclude the entire call. And based off of the nature of the call and the fact that the phone is passed around multiple times, and it's hard to determine who's speaking at what times. And obviously, a lot of emotion in their voice, considering what's going on. It's not always clear to understand what's being said, so I think a transcript is a fair way also to convey this and should be allowed with the audio. Nothing further from the state.
Transcript and testimony? In other words, you're essentially admitting the evidence of somebody who transcribed it to say this is what they said. So to me, there's two different questions. One, should the 911 call come in? And second, should I allow, if there is a disagreement, a transcript?
Well, the state has offered to allow the defendant's transcript that they had certified.
The fact that certified doesn't make it otherwise independently admissible. It's hearsay. The transcript part of it.
Well, it's a transcript of the 911 call. I believe that it could be self-authenticating. It has sufficient standards of reliability built into the transcript.
That may be one. 24 might be a hook. You haven't complied with the requirements of 24 at this point, but
No. But we haven't met our exhibit or witness deadline yet. So obviously, we would have to lay the proper foundation for that and would intend to do so. Thank you.
all right, I think I need to take a statement by statement approach to this. Do you think that the surviving roommates, surviving victims of the burglary were under the stress of the immediate events, but there are some questions about some of the other statements in there as to whether they would come in. So I think, in general, much of the 911 tape meets the qualifications, but not all of it. I think there are concerns with some of them, as I've outlined in my questions. But I will write that because to give you more particular guidance. All right, the text messages and testimony.
Thank you, Your Honor. Similar motion by the state, asking to bring in the phone records for a DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to come in. I broke those down in my motion and reply, and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay. It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that BF responds, I think all of those are allowable under the excited utterance as well as the present sense impression exceptions to the rule against hearsay. If you have any questions about any specific messages.
Well, Your Honor has our exhibits already related to this, and then in the record were BF's phone activity. I don't need to quote extensively from those. There's a lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit. I understand from the court's previous statement that the court would accept a complete copy of something versus just pieces of it. Well, I could offer
Qualifies for
it.
the completion doctrine. If it's necessary to explain the prior admitted stuff, and it's close enough connection in time and in subject matter, and so there's some questions there. It's not just automatic.
We certainly would understand that we'd have to present some information or cross-examine witnesses about that. The additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people, and it's hard to tell what it is because there's telephone calls. And those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging. And the whole is what matters here and takes it away from being excited utterances because of the other activities of the two people.
The activities that occur after, so for example, the texts between, at 4:18 or 4:20 or whatever, those aren't affected by the later activities of, surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies because my experience with that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing, right? And so understanding how they're using those apps is also important.
It is important, and I would refer the court to our affidavit from Mr. Roloff talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone, and those are things that were going on as well as editing pictures. The picture editing happened in those overnight hours. Instagram happened later in that morning.
That wouldn't affect the excited utterance and present sense impression of the earlier 4 o'clock text, I guess is my point, because those are afterwards. Those are after they retreated to the room together and, and what happened there.
Mostly I agree. There were things that happened right before DM created a new contact at 3:51 in the morning.
Before
There-
anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
The foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous. And there is a break for BF, but it starts again right away. So I understand the court's looking at an isolated part of time, but I think it's important to understand what activity was happening leading up to that and what activity happened immediately after that, when the two of them are together downstairs, to put it into context. One of the other concerns is the use of this text messaging, not just through the witness that's testifying, but to bolster each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning, the one's continuous, but right after.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion, right? So, is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means it's an out-of-court statement, then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance, and then we look at the surrounding events. Is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.
All right, next item is the demonstrative evidence.
Thank you, Your Honor. In our motion regarding demonstrative evidence, we were talking specifically about, for lack of a better phrase, a dollhouse, a not-to-scale construction, a 3D model of the residence itself. And as the court can see from the materials that have been submitted, the configuration of this house is unusual at best. Certainly we can use diagrams and floor plans, which we did at the grand jury, but it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out. What is on each floor, where the bedrooms are, how the first floors.
Well, for it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. The concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed, and where everything was located. So it's not intended as a standalone exhibit that has significance. It's only a tool for the witnesses, not just the roommates, but the responding officers, the officers who investigated the crime scene, to point out to the jury where in this three-story structure certain things were that they observed. And so that is our intent on this. We initially contemplated offering a two-scale model. And the defense, I think rightfully so, said, okay, well, give us the background information and data that would be relied on. And we requested that, and for whatever reasons, we didn't get it quickly, but as we revisited it, we realized that to scale maybe is not what we want. We just want a demonstrative exhibit that witnesses can use, much the same as a sketch, or if they would take a flip pad and try to draw things, to help illustrate their testimony to the jury. So that's where we ended up here. We look at the balancing test under 403 as far as relevance. We believe this will be helpful to witnesses and explain to the jury and to the jury in understanding witnesses' testimony. As far as prejudicial effect, the state doesn't perceive any significant prejudicial effect. Now, I realize that the expert witness for the defendant talks about jurors misinterpreting angles of view and stuff. Well, that would be true if we were dealing with a two-scale exhibit, and the defense is welcome to offer their 3D imaging or whatever it is that they want, if they want to have a two-scale presentation. That's not our intent, though. Our intent is just simply to have this as a tool to help witnesses explain their testimony and help the jury understand.
And I think you understand this, but so that, it's clear. If it allowed as a demonstrative exhibit, it's not an exhibit in the sense that it goes to the jury. When they deliberate, it will not go back with them.
Yes, we completely understand that. We intend this to be something in the courtroom that is physical, that the jury can look at and the witness can look at and point to things so the jurors have the most complete understanding of what their testimony is.
And I haven't seen it, so I don't know how visible it will be to, you've seen now where we're going to be, how visible it's going to be to the jury from where it would be presented. So I guess if I allow, we'll have to cross that bridge.
And that's understood. The last communication we had earlier this week, Your Honor, from the folks at the FBI is that it might be finished within the next 10 days. I'll be candid, I had proposed to the FBI, let us get this in front of the court and get a preliminary ruling from the court before you spend the effort to construct it, but they went ahead and started anyway. So that's neither here nor there. It is intended, as you can see from State's Exhibit 1 or S1 with the dimensions in there, it's a fairly significant size, 35 by 48 by 52 inches. So the idea of making it big enough so the jurors can see, it's out in the floor in the well, and they can actually see how things are constructed and arranged. It can take apart floor by floor so they can see each floor individually and then how they are stacked back together. So that's the purpose, to assist witnesses in explaining their testimony and assist jurors in understanding the testimony.
Your Honor, we request that you exclude the state from using this dollhouse model, as is everything we're talking about here today. We're talking about Mr. Kohberger's constitutional rights, and we're talking about the rules of evidence. In this case, though, Your Honor, this goes beyond that. This is something that came up in 2023, the fall of 2023. We were disclosed that a group was going to the house before it was torn down to construct a model. We promptly asked in discovery to receive information about this model so that we could start to understand it, so that we could work with our expert with it. And it wasn't until 2025 that we get more information about this. I don't think that calling it a demonstrative exhibit excuses what the state has done here. The state said they didn't have any of the materials, they didn't come forth with them. Their date to be done with discovery came and went. Their date for their expert disclosures in December came and went.
Here, demonstrative exhibits and trials are typically not brought to light in terms of being shown until oftentimes during trial itself. I mean, it's no different in some senses, as I'm hearing the argument, of sketching on a diagram on a pad.
It's completely different than sketching a diagram on the pad, Your Honor. This, if somebody's drawing something in open court, I can see them. Mr. Kohberger's confrontation rights about how that's drawn exist right then and there if they're drawing something on the board. This is an exhibit that's constructed outside. It's done in preparation for court. There were experts that took the 3D imaging to make this. There were photographs that were taken to make this. There's a process to construct this and to take it from to scale, which might have made some sense because things would be there where they're supposed to be. And by things, I mean walls, I mean doorways, I mean angles of hallways, I mean lines of sight. Those things would be there where they were supposed to be if we were doing this to scale. But to not do that and call it a demonstrative exhibit so they don't have to tell us about it is really misleading to the jury. And there's a lot of danger for the jury to be completely confused by that. I don't think this change excuses what the state did, to sit on this information and wait until the last minute when we don't have any ability to investigate it or to look at it.
You had access to the house, right?
No. What, to the old house? Yes, but not to what they're doing now.
But you had the ability to create your own models, to do your own measurements, to come to an understanding of the layout.
Absolutely, we did. What we don't have the ability to do now is to test the state's model before it gets in front of a jury, before different witnesses use the state's model to say, this is where I was and this is what I could see. If a doorway's just off, the line of sight is just off. That can be completely misleading to the jury. This is an unfair surprise to Mr. Kohberger. To have this come in and have the jury look at this, it's not a PowerPoint. It's not a drawing on the board. This is going to be this big 3D model that's going to be pushed around the courtroom. It's going to draw the jurors' attention. They're going to put a lot of emphasis on it. A demonstrative exhibit that may or may not be accurate, that may have the walls and the lines in the right place or the wrong place, that won't have depictions of furniture or the way the house really existed that night. And the jury can place great weight on that, and it might not be actual. It could skew the testimony, it could skew the truth, and that's really important in this case.
Where cross-examination comes in?
Your Honor, how can I cross-examine a 3D model that's constructed outside of a way I know anything about?
Well, you had access to the house and you know what the house looked like and you have photographs.
I do have those things, but if there's a slight shift in this 3D model, it's going to be more difficult to depict that. And that's a lot of runs around to try to get our expert to take a look at this, to try to get our expert to pull the 3D picture that would show that this model's wrong, and to try to get the jury to want to listen to all of that, when the best and easiest thing for the court to do is just exclude it. This is not a model that will do anything but cause the jury to speculate. It could easily produce testimony that's not true. The jury might be relying on things, and likely will be relying on things that are not true. When you look at the case law that talks about demonstrative exhibits, you're looking at things like PowerPoints. You're looking at, that's in the Weigel case, whether or not the demonstrative exhibit should go back to the jury. When you're looking at the Masters case, it's an exact car seat. That was a civil case. It's an exact car seat, like was in the case at bar at that time. Here, this demonstrative exhibit that's going to be large may or may not be accurate. Conversely, I have the photographs, so does the state. I've been in the house, so is the state. There's 3D imaging that was taken by the state and by the defense. With all of the thousands of photographs and all of the people that have been through the house, there's no reason to take a chance on this exhibit that will be speculative and will confuse the jury. To allow this is allowing the state to ignore the discovery process. They're just slapping a new label on this model and saying it's not to scale, so we don't have to disclose anything to you. To allow them to rename this is a violation of Mr. Kohberger's constitutional rights to due process and a fair trial. This should absolutely not be allowed. Mr. Kohberger we have done everything we can to be apprised of what the state's going to do, and at the last minute to pull this out after we've asked in discovery for this and to label it a demonstrative exhibit, Your Honor, that just can't happen if Mr. Kohberger is to have a fair trial and if his due process rights are to be adhered to. We strongly object and ask the court to order this excluded.
The 3D, or in the, I don't know if it's LiDAR or what they use, the 3D information.
I'm sorry, Your Honor.
Do you have the laser information,
As of March 4th or 5th, I think that we did receive that. We sent that to our expert. He wrote a declaration in support of our objection to this to let you know how long it would take him to do the work necessary to even measure this, and then he'd need an on-site visit for this. And if the court allows it, that's what we have to do. But the court should be well aware that when the state does these kinds of things, these things mean taking their time and throwing things out long after deadlines come. There's a ripple effect that happens. We have to work with our expert. The expert has to carve out time in his schedule. We have to take time to understand what's happened and figure out how to respond to it. We are very close to trial, and those deadlines are important for a reason. All of the stacking up of things like this at the last minute outside of the deadline set by the court and outside of the rules further prejudice Mr. Kohberger and his ability to have effective assistance of counsel at trial.
Your Honor, what Ms. Taylor is talking about might be true and applicable if we were offering a scale model. We made the decision not to. She complains about the timing of the underlying FBI data. Well, that request from her for that information related to a proposal for a scale model. And we provided it anyway because she had requested it. In our view, it has no bearing on whether the demonstrative exhibit is acceptable and appropriate. The allegations that we've tried to sit on this and bury this, that's just silly. That's not what happened. We provided the information we received. As soon as we received it, it was processed. I don't think that the defendant can point to anything to say otherwise than that. It's just simply a demonstrative 3D model to help the witnesses explain their testimony and help the jurors to understand the testimony. That's all we're asking for.
thank you. I will give you a written decision on this soon, shortly, but there is a significant distinction between demonstrative trial exhibits or trial models, charts, things of that nature, and attempts to use things for evidentiary value in and of themselves. The more complex, it's not particularly different than a drawing by a witness or something of that. It's not uncommon to get these very close to trial. Defense counsel has had access to the house, could have done its own diagramming if it had wanted to. It has now the information on the, I'm just going to call it the laser or LiDAR modeling measurements, whatever that was done by the FBI. It's April. Trial is starts in August. I think there's plenty of time for the defense to respond to an item that is not actual evidence. It is simply part of testimony that will be forthcoming at trial, and will not go to the jury. Jury will not have it in its presence when it deliberates. I don't see, frankly, concern with respect to the use of a model in a case like this. So I'm going to allow it. The state will make it available to the defense prior to the pretrial conference, and sooner if it doesn't sound like it's complete yet, but as soon as it's done, and certainly as quickly as possible. And like I say, it's not going to be allowed for evidentiary value. It will be a part of the testimony. Whoever testifies is going to have to testify that it helps explain their testimony and that it's consistent with their observations. That's subject to cross-examination by counsel if there are problems with the model in terms of view lines and things of that nature that they were able to put together through their own visits, through their own studies, through their own opportunities, including through their experts if they want to. So. All right, next I have self-authentication of records and reliance on 803. I'm not sure we're ready to argue this because I don't think the state has complied with the obligations in order to rely on the self-authentication issue if they haven't provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah, Your Honor, we agree. That's probably an accurate statement, and a better time will be after the exhibit witness list is due, and then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a meet and confer over the exhibit lists to determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. Can I add anything, counsel?
No, Your Honor, I won't right now.
All right, let's talk about alibis. This is the state's motion in limine.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor's staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights. And they're certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because the defendant's phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point, and to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There is nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the ability, the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration, now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue, and I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on and 4, so whatever it was.
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi, and a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well,
it's that,
why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness,
yes, sir.
or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right.
All right, let's talk about the AT&T stuff.
Thank you, Judge. This should be fairly simple. The state's seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump, and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period, so the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window, so there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
Defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're talking.
You're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
Right. I have nothing further, thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance records.
What evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific.
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that
It's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
So the 7 days that he's back home,
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
You would
which
agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance records.
Because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay? So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't, because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. but the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my
My
attention more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you,
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
he is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and provided AT&T's sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel, through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do, and that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available
And I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that, and I'm not going to allow testimony about that. Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it, but you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you. All right. The vague and undisclosed expert testimony, I think in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts, and so I wanted to provide that to the court.
I did see that and read it.
Okay, good, thank you. Let me get to my same page. I want to start, though, today with my presentation and my request with a little bit of history with this case, and as the other motions are, this motion, our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
Well, to be fair, and in the way I handle these issues with Rule 16 in the criminal context, the rule is not particularly broad about what is required. And the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts to encourage sharing beyond that which is required, because I think it helps both sides. And I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better. And I think it creates just a more fulsome picture of things that way. And that's why I invited the state to supplement. And I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16, and so that is my guidepost.
Well, Your Honor, I believe Rule 16 references the Idaho Rules of Evidence, and I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, it's the State versus Morin case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have, this is how we're going to prove this case, and for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Kohberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We tried to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, Agent Balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance doesn't, the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
Allowed to give an opinion about those last 7 minutes?
I'm sorry?
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion, their expert to have an opinion.
You can't, and we're here asking you to limit what they can testify to by surprise once we get to jury trial. Agent Balance is worth further comment to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done, and to understand that he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage, and then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you, though, while we're on the topic of that last 7 minutes, that it's more problematic.
That was part of the initial disclosure, correct?
The PowerPoint, I believe, was provided as a disclosure.
Did he testify for the grand jury?
No, nope. Officer Mowry, Detective Mowry testified before the grand jury. Agent Balance did not. So I don't have any of his testimony. But I want to tell you about the 7 minutes. And I want to tell you that those are problematic. When the phone's moving, when Bryan's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative.
That's just impeachment.
Well, it's actually exculpatory to Mr. Kohberger, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that. And I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony from your expert about that 7 minutes and impeaching him about, you didn't even look at the last 7 minutes. You missed that. And what could that mean? Couldn't it mean as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
well, I anticipate impeaching for the lack of diligence. Here's the fear, though. I don't know what he's going to say about those 7 minutes, so I want to impeach him about that. I want to impeach him about a whole lot more, too. But if I do, and he says, well, I did analyze it, actually, I hope the court's order stands and he's not allowed to talk about it.
You have to be careful about what doors you open, but
I agree, and when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce a thing. they have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline, and they didn't go home from the January 23rd and 24th hearing when the court said, your job's not done, I'm not gonna allow things in that aren't disclosed. They didn't go home and say, we gotta get this done now. They trickled things in, bits at a time. And that is just not the way the system works, and that's in violation of Mr. Kohberger's rights, and we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position, and that's the way to bring it back and keep the burden at the table it should be, and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. We had a lot to say about that with Agent Balance.
Search warrant application include the analysis of the cell teller information?
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
That large, omnibus document that they used,
Oh, Exhibit 1 that was attached to all of them.
attributed to, if not the signatory, but the FBI CAS team.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit, or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he
My point is
dictated
that
it.
were you on notice of what the state's version through the CAS team of what that data showed?
If I look at the affidavits, there are a few things, yes, that I would be on notice for. They're not attributed to Nick Balance, but there are a few things. Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it, and let me tell you what I mean.
Talk about the adversarial part. I also looked then in that case at what information you did have about what the state's case was. And so, it seemed to me that in general that cell analysis was part of that, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion, and now for the first time, I know he actually analyzed it. What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis, and then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
As I recall, the 47 said it was traveling southwest.
Well, that's what we say. That's what the record shows.
That's what the application said.
The application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time, southwest of Pullman.
That's not when the phone stopped reporting.
I realize that, but it's not like they were representing that it was at 2:47, halfway to Moscow or traveling to Moscow. It said it was southwest of Pullman, which, as I understand, the 2:52, 54,
70.
7 minutes later indicates that it's traveling southwest to Pullman.
None of the search warrant affidavits have anything about 2:54. It was,
I understand that. My point is, the time was wrong, but the point, the direction of travel is the same.
there are paragraphs in the affidavit that talk about the phone traveling towards Moscow. There are slides in Agent Balance's PowerPoint that have an arrow, and that's not true.
Well, there is a, in the search warrant affidavit, I think as part of the PowerPoints, I don't remember the language it used, but basically the believed route of travel or something like that. In other words, their opinion of what the travel route was. And so that was disclosed, what that alleged travel route was.
Cell phone records would indicate something different than they said. So if, and I see what the court's doing. The court's saying, okay, you have this PowerPoint, what else were you on notice of? I'm on notice of things that the records contradict, the records being the AT&T records that we received from the state. And those records contradict those things in the affidavit. I'm also on notice.
Allow for supplementation of expert disclosures to correct errors, to provide new information, to make them fuller. I mean, the rules allow for that.
That's not what they've done.
I understand that's what you're saying, that's what they haven't done.
That's not what they've done, Your Honor. And
That's why I'm looking at what did they actually say beforehand, because I think part of it is a notice issue to you.
well, I'm on notice of things that the records don't support. I'm on notice of a PowerPoint that doesn't have any analysis or opinion in it. So those are the things that I'm on notice for with regard to Agent Balance testifying. So I'd ask the court to not allow him to testify beyond the December 18th very limited disclosure. We have the disclosures that still have some vague language in them, and we talked about this back in January, where it's imperative to not let people offer opinions based on this vague language that they can change their opinions. That happened a lot with lab people. There were some additional disclosures with lab people bringing in CODIS. That came in the
That's not an opinion, first of all. It is an explanation of why they didn't submit evidence to CODIS. I'm not seeing that it's an opinion. That's just a statement of what the facts are.
Your Honor,
It's not expert testimony. That's, here's our policy, here's when we submit stuff to CODIS, and here's when we don't. And this has been raised as an issue. Why didn't this get sent to CODIS? And this is why. I don't see that as an expert disclosure issue. That's purely a factual issue.
the protocol allows the individual, a certain analyst, to make that decision. That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is I don't really view that as as expert testimony. That is simply the underlying factual happenings. It's like, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. In my expert opinion, I thought it'd be good to call this person. These were fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over-disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the stair rail DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can.
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, it was the DNA of Y person.
Right. Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to. With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation but not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify about other things. And as long as they're kept to those opinions, I think we're informed on most of those. Again, not going through every one. I do want to talk about Dawson, though. Dawson was an expert that was disclosed in rebuttal, but there was nothing to rebut. He's an expert that talks about toxicology, and we are.
Didn't you produce an expert who said that that there wasn't it would have required two people to commit the crime?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That doesn't.
Dawson testimony about the degree of intoxication goes to the, what I'm assuming was given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway, so this would seem to be contradictory with other testimony that they intend to put on. We are not contesting the intoxication level of any of the deceased.
I understand your argument.
Thank you. Again, Your Honor, I think that our exhibit stands on its own, and I just wanted to highlight a few of these. I do want to talk about the cell phone and third-party data, digital data disclosures. We have a little bit more in the way of opinion now, but not full opinion. And the state said that we didn't give them enough to rebut, and that's because we don't know what opinions their experts are going to come up with. They still haven't disclosed full opinions, and so we want to highlight that for the court.
What haven't they disclosed?
Well, in the Barnharts, they said they were going to talk about habit evidence. I don't know what that is. Most of the rest, there were three, Mowry, Urig, and Tanzola, that looked at the digital data and the cell phone data. I don't have any idea what they're going to talk about, except Urig is going to say that there's no connection between Mr. Kohberger and the others. That's the only actual opinion that's been disclosed in that. The last one I wanted to highlight for the court is the Douglas, Special Agent Douglas's testimony. That seems to have shifted a bit from he's going to talk about bank records and debit purchases, and it's become bigger without any opinion. I don't know what his opinion about anything will be. That needs to be limited. I think he can come in and talk
Through the financial records and say, this shows a transaction with Mr. Kohberger's credit card to purchase a Amazon gift card, and that this Amazon gift card was used to purchase a knife.
if he can say all of those things. I think that his ability to talk about receiving the bank record and looking at it and saw a purchase history, I think that's fine. But to provide an opinion about what that means, that's not disclosed. Well, Your Honor, I don't want to wait to find out. I'm asking the court to.
My point is I'm not in a position to exclude their testimony because they haven't shown me that they're offering something beyond what they've disclosed.
Your Honor, I respectfully believe that the court is in a position to limit what hasn't been disclosed and would ask the court to do so. The state has had a lot of time to provide these disclosures to us, And what they've done is taken the advantage of having our disclosures and bit by bit giving them to us. This is challenging to prepare a case of this magnitude in any event, and to have things piecemealed out just delays our preparation time. And it's also in violation of the discovery rules, it's in violation of the court's order, and it violates Mr. Kohberger's rights to a fair trial, effective assistance of counsel, and due process. And it is within the court's realm to say, you're not going to do any more after this particular date. There's no opinion written down for certain people. It can't be offered now, and we think that's what the court should do. If we wait until we take it as it comes during trial, that's better than nothing, but it's very difficult to prepare, and it eats into what limited time we have to prepare, and it will waste a lot of jury time to have to take these things up again and again and again. The state knew what their duties were. They've done this for a long time, and they chose this course of action, and the court should limit what they can do and issue an order limiting their experts.
Defendant makes a lot of assumptions about what has occurred. However, I can tell you the state didn't wait to see what the defendant was going to disclose first. That would be an incredibly risky game for us to play. And that's not what happened. We know what happened. As laid out in the state's response, the state filed our initial disclosures on December 18th, 2024, disclosing 25 experts for the guilt phase. And then at our last hearing on January 23rd, the court addressed this issue. And Your Honor stated and issued a word of caution, instructing the parties that the disclosure should cover over-disclose. We should really go back to our experts, lay out, and you talked about the amount of work that this would take well in advance of trial to go through everything that they intend to testify to and put that into a disclosure. And that it doesn't go as far as the civil rules, but that you didn't want to have these issues coming up at trial. You were very clear in that you directed to the state that our work was not done. We took that to heart. You did not set a specific deadline, but instead instructed both the parties that supplements would be reasonably allowed. In response, we did immediately go back. We went back to all of our 25 experts and asked them to review their testimony. We had to have several meetings to discuss what their testimony was going to be, and they supplemented their disclosures. On March 3rd and March 14th, the state filed the supplemental expert disclosures. I submit to you that the state has complied with Rule 16. We have a continuing duty to supplement. The defendant has filed expert disclosures past their deadline. The state has allowed that. We are trying to be reasonable in this. And in fact, in that stipulation to allow them more time to disclose, we stated, it serves the interest of the parties and the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. That's where we're at, and that's what we're asking for. Thank you.
If we were talking about one expert of the state's, that might make sense. We're talking about wholesale not complying with Rule 16 and with the rules of evidence regarding experts. When we realized that the state hadn't complied with the rule and provided us very little in the way of understanding how their experts would frame the issues in the case, we sought an extension to prevent the state from having our work first so that we could try to respond to what their expert disclosures were with our experts. That wasn't something that was given to us. That was denied, so we filed our expert reports. For us to have a couple of experts that came later when the state has done their job as they've done their job, that is really a hollow way to say they did it so we can too. The state did not comply with Rule 16 or with the court's order, and the court should limit what they're allowed to produce at trial.
All right, I'll take that matter under advisement. I want to, I did invite the parties to supplement. It takes time to supplement. I'll look through to see if there's any significant new additions. Well, first, I'll look to see if there's, what is given is adequate. If there are concerns. Secondly, if there's anything that was provided that wasn't shaping and as I've said, making more fulsome, making more whole, making more clear what opinions there are. The defense I know was given, and as I explained, the defense has the ability to supplement as well in response to the state's supplementation. Part of the reason the discovery order is as early as it is to the trial date in this case is because in my experience in cases of this, we have this problem always of ongoing, continual supplementation and disclosure, and so I wanted to accommodate that within the time frame, within the several weeks to months in advance of trial. And so I'll look at it and I'll get you an opinion. All right. Amazon click activity.
Judge, this issue really ties into what we've just been discussing and I think is illustrative of the problem. So when motions in limine were due, we had notified the court that we didn't have expert disclosures on opinions on Shane Cox, who was going to be their Amazon expert, and Michael Douglas, who they had listed also as having information about Amazon. So when we raised the issue with the court about incomplete disclosures, like Ms. Taylor was talking about, we still didn't have those at the time that it was time to file a motion in limine. So our motions in limine. So the motion in limine related to Amazon Click and Amazon Records has to do with a lack of disclosure. When we filed the motion in limine on Amazon Records, we then got supplemental disclosures on Shane Cox and Agent Douglas, but not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
There may
talk.
be some rebuttal stuff in there based on your disclosures in terms of why the Amazon data, as I understand it, you're saying shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation than that. But the issue is that we had received this data and without expert opinions to explain what the state intended to do with it, it left us in a spot of trying to figure that out.
How was it vague what they were trying to do with the Amazon records? It was pretty facially evident what the relevance of those
They're
were.
not facially evident, Judge. We have an Excel file that has a ton of names with metadata, and then we have what is known as an Amazon click packet that the state has produced, we think from Shane Cox, that has a sheet that talks about specific purchases that include the knife, include things like the gift card that you were just talking about. but without any context. And our hope was that with expert disclosures, we would understand, was there going to be testimony from them that somehow there was information on computer searches, specifically from computer examination, or the context of what metadata might explain about the ClickPay documents that they got. We now have some information because we have got an Amazon expert who has explained to us what we have and what we are missing. Obviously, the evidence is important to the state's case related to the Amazon information. And given the court's direction about its intention for us to call experts today, which Mr. Howell is available, we went ahead and submitted a declaration when the court said that you were disinclined to allow testimony, and we sought leave, but we didn't get a solid answer. So you've now got an affidavit in front of you, declaration.
Typically in motions in limine, I'm not being in a position to make factual credibility findings and the like, and so the testimony on paper is more than adequate to guide the court.
Okay, I appreciate that. So I'm going to explain then what the basis is for where we're at. The other issue that of course the court knows is that we sought to seek suppression of the Amazon records because the warrants were extremely broad. We expected to be getting significant data or have data that we hadn't yet reviewed. The court denied that suppression issue. And so what we know that we have now is the list that I explained, but it's without metadata. And so for the purposes of what we've got going on here, there is, pursuant to Rule 106, a whole level of context that's really important to the Amazon data. And it's not just AI technology, it has to do with machine learning. And I think a lot of this is something that
AI.
Pardon?
Isn't that AI, machine learning?
I think that machine learning, I'm definitely not an expert on this, Judge, but I've provided you with a declaration, and if you want me to put Mr. Howell on to testify about
That's
the
not
difference
important.
between, he's far more articulate at it than I am. It's a combination of both with what happens with Amazon, because in terms of machine learning, one component is that when there's a household account where there's multiple users with multiple cell phones and multiple laptops going into purchases, there's machine learning and cross references there. In terms of the way that Amazon works as a company globally and artificial intelligence, they're doing all kinds of things to understand what consumers and purchasers and sellers are trying to do to actually prompt people to buy certain things. So in this instance, with regard to these purchases, we have very limited data regarding Mr. Kohberger's purchases without the metadata and the context. And that's the reason that we are seeking to exclude it. Now,
Well, you got what they got, right?
not really, because what we have is, we know that they're going to draw conclusions and that they're going to draw conclusions about intent, but the way that they've presented it to us in data is that this relates to Amazon clicks. Well, Amazon clicks makes it sound like to me and you, someone goes on and actually, with a mouse, clicks, opens a document, takes it into a cart, purchase it, and it's a much broader term than that.
And the state's testimony from their person who will testify that this is what the Amazon data shows, is that Amazon data shows that Mr. Kohberger, at least his name, purchased the knife sheath and cleaning thing, knife sharpening, equipment, and looked, as anybody who orders on Amazon does, is it
Where's it at in delivery? And then later on that same account, after the homicides, looked at knives again. Now, I understand the defense's position and evidence and expert to be that, well, that's a shared account and anybody could have done that on that shared account. I don't know that that's a matter of exclusion, though. Isn't that a matter of just impeachment and cross-examination and your own experts?
That if the court doesn't exclude it, then that would be the remedy and the approach that we would
Would
take.
it ever be the remedy of exclusion?
Judge, if you don't exclude it, then that would be the alternative, I guess.
What basis would I have to exclude it?
I started with that we did not have expert opinions at the time when we had to file a motion in limine regarding this data, and it's misleading that the way that you just portray it, that because there is a purchase in a household account, that is automatically attributable to him, and that there's somehow
It's not a purchase in
intent.
a household account. It's attributable under his particular name in the account, as I understand it. Now, could somebody else in the family get to it? I don't know. I suppose your expert will tell us that. But I'm not sure how that is excluded, and I'm not sure how that's expert testimony. I understand you have an expert to say, well, you know, all these other factors come into play and all these other things could have happened, and okay, you can put that on, but I'm not sure why that excludes the state's evidence.
Well, it would be extremely misleading, given the declaration that we've put before the court about everything that goes into the way that Amazon
You're
functions.
asking me to be the fact finder again. I mean,
I'm not asking you to be the fact finder. I'm telling you that when we don't have complete disclosures and we're playing a guessing game of what this information means, and we have deadlines where we have to file motions, then we end up in this circular situation right now, right? Because we had to file a motion about this without knowing what the opinions are and what we're lacking in data. Now I have an expert who's explaining it. We've asked you to exclude it. You're indicating you don't think it's an expert opinion, and so then the next logical step would be our expert comes in and we're allowed to confront the evidence. But you also just proffered that, you know, that based on the information that you understand, that equates to a purchase, and I've put a declaration in front of you from an expert that says that Amazon doesn't work exactly that way. And that's the problem, that when it is represented as a click, that indicates to the average person that he sat at a desk and clicked and made a purchase when there's a lot more to them.
and maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
No, that is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works, right? And so the state wants to apply in an argument, they will apply intent to purchase a K-bar to get to November
It's an
13th,
inference that you can draw
2022.
from the evidence to argue at closing arguments.
But we still have to have testimony that explains those things in between.
Welcome to put on testimony that implies that Mr. Kohberger was not the one that hit purchase, or that he purchased it for a benign event, or that here's the knife, I have it. I don't know.
And based on what you're saying, that the Mr. Cox you think is a lay witness, then I'm assuming that also extends to him not being able to testify beyond what the disclosure is as a lay witness and no other opinions, and including Agent Douglas, who's given us no opinions whatsoever.
I don't know what they're going to say beyond that. And if they say something beyond that that is an expert opinion that hasn't been disclosed, then the state's going to have a problem with it.
Okay. That's why we're having these arguments, Judge. They take a lot of work. It takes a lot of energy. It keeps us from 68 terabytes of evidence.
Well,
If everybody would just disclose, we wouldn't be having this
But I
back
think
and forth.
the problem is you view it as a more complex issue than the state does.
Because it is.
Well, that's not their worldview,
okay? And that's the factual dispute that the jury gets to decide.
So what we're trying to do is make sure that their myopic worldview is what they're held to, because there is a much bigger picture to this evidence. Okay.
Judge, this is pretty simple. Shane Cox and Mike Douglas, since he gets brought up, they're fact witnesses. They're not gonna have opinions. They review records, they're gonna testify to what those records show. Shane Cox's testimony is laid out in the supplemental amended disclosure. This is exactly what he's gonna testify to. And what he's gonna say, he's very careful in what he says that he's gonna say. That's what we're anticipating. There is no grounds to exclude his testimony. We applied for and we were granted a search warrant for Bryan Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories. It directed law enforcement to see certain items: his customer click activity pertaining to knives and accessories, his payment methods used, details of items in cart, including all items added to the cart or removed from the cart or wish listed or in a shopping basket, all suggestions made to the account, all records regarding reviews by other Amazon users, advertising data, devices used to connect to the account, and all accounts linked to the account. The state requested the data between limited time periods, March 20th to March 30th, and November 1st to December 6th. Those were the relevant time periods. And in response, we got responsive data, and that's what we plan on presenting to the jury. Amazon's use of AI is not a basis to exclude, and it's completely irrelevant. AI doesn't click on things for a user. There are no legal grounds to exclude this. We ask that you deny their motion. Thank you.
Thank you. So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it? What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those or without a rebuttal disclosure to some of the things the defense has disclosed on that, then they're not going to be allowed to testify to it. But there's not a ground for exclusion because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence. All right, let's take 10 minutes, and then we'll see if we can't bring this home. All right, we are now at the state's motion regarding neuropsychological and psychiatric evidence, as well as then closely followed by the defense's motion with respect to autism spectrum disorder.
Thank you, Your Honor. I hate to sound like a broken record, but once again, this seems to be a developing issue. The basis for our motion when we first filed it was in response to the defendant's supplemental responses on experts, the declarations of Dr. Orr and Dr. Ryan. Each of those talk about mental condition. And each of their disclosures, right on the first page, said that this evidence is not intended as mental element defenses under 18-207. So our response was, well, then it's not admissible. It's just very simple. The statute covers that. What happened after that is that it morphed now into a new position from the defendant that there are neurobiological and physical conditions that are come into play. Not to the exclusion of the mental conditions that were alleged before, but Dr. Lewin talks about the physical conditions are predominant as opposed to exclusive. So that kind of brings us to where we are for the issues for today, and I'll try to be as succinct as I can. The first issue, what was initially raised by the defense, is they expressed concern about how the defendant's demeanor is going to present to the jury as the defendant is just sitting in the courtroom at counsel table like he is right now, and assert that they should be able to offer evidence that the defendant has autism and these other disorders that make him appear, I guess, arguably like he's not involved or something in a negative fashion. The defendant cites no authority for this, and indeed, I'm not aware of any authority. We can't find any authority to say that the defense can come in and even before jury selection say, okay, ladies and gentlemen of the prospective jury, here's this expert testimony that our defendant has this developmental condition, this autism condition, and so he might appear different in court. And so please don't hold that against him. There's just simply no basis for that, and we looked for that. It's irrelevant to any of the factual issues in this case. It's irrelevant to the elements of the offense. Frankly, all it does is confuse and try to play the sympathies of the jury, which is exactly what Rule 403 would prohibit. And we cited to the Schuler case where it talked about in the context of prosecutorial misconduct, it talked about the defendant's courtroom behavior off the witness stand is irrelevant. I think it stands for that. The defense argues that the Samuel case expands all of 18-207 to include mental conditions that don't directly relate to an element. And that's simply a misreading of the case. Samuel dealt only with subsection 4, which deals with the state's ability or right to request independent examinations. And the Supreme Court said that applies to any mental condition evidence the defendant opens up. It doesn't change the first sections of 207, which limit the defendant from presenting mental condition evidence under